This leaves Congress with the ability to pass laws and administer them without any judicial interference in many cases, which I think is seriously problematic, which is why it changes. Now, by the time in July 26 they submit the provisions of the Committee of Detail, which by that time they produced this long, sort of ponderous document with all these provisions in it. They gave it to the Committee of Detail to flesh it out and give it a little bit more order and form. Well, whenever they submit the provision there, it's changed dramatically. It says that the jurisdiction of the national judiciary shall extend to cases, again, not all cases, just some cases, arising under the laws passed by the general legislature. So any federal law, and to such other questions as involve the national peace and harmony. Now you notice something missing here. It says nothing about the Constitution or treaties. So constitutional provisions and treaties would not provide an automatic justiciable area of judicial activity. But by the final wording, whenever the convention finally adopts the Constitution on September 17th and sends it to Congress to be forwarded on to the states, the anniversary of which we celebrate today, we get a much more extensive, not just coextensiveness, but actually the judiciary's jurisdiction under the final wording exceeds that of Congress. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, treaties made or which shall be made under their authority. This means that the judges can hear any case that implicates the Constitution. This gives us a lot of cases that fall completely outside of congressional jurisdiction. For instance, the limitations on states in Article 1, Section 10. It wasn't clear that Congress could legislate to enforce those, but here we have the grant of jurisdiction to the courts to get not only into the administration of federal laws, but to get into the administration of state laws insofar as those implicated the Constitution, something that even Congress couldn't do. So I think you can see, just from this brief overview, and I'm sorry, this seems awfully impoverished to me. I wrote an 84-page chapter on this in my dissertation. So imagine how brief I'm being. I'm being very self-restrained. Aristotle would be proud of me. But you can see just from this brief development how much the judicial role expands as we go through the convention. And this is quite conscious. I mean, the delegates are conscious of what they're doing with this. And even if some of them are not, the logic is simply there in the instrument, and it's there in the debate, even if some of the delegates can't quite see it. Now, I think to bring this into the present, I've already mentioned that many of the functions now performed by independent regulatory agencies, or at least arms of them, such as administrative law judges, are in fact judicial in character. As I suggested already, I think this is, in a really ironic way, a substantive return to the Articles of Confederation, to a system with legislative supremacy, where it's assumed that Congress can create bodies that simply take care of whole areas of policy, where they've excluded the judicial function, but they've not allowed the federal courts to perform the judicial function. They've instead created alternative institutions that adjudicate cases over individual claims about their rights and interests and the application of federal laws to them. So I think if we look at the Constitution is quite consciously meant to free executive and judicial functions from legislative control. The development of the language pretty clearly establishes this, and I think you have to look no further than the vesting clauses. The Article 3 vesting clause here, the judicial power shall be vested in one Supreme Court. You have to look on the other side of the page, I'm sorry. Section 1 of Article 3. The judicial power, whatever that is, however expansive it is, if it's judicial power and it's held by the government of the United States, the judicial power, the whole of it, shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. I've put here on this page as well some excerpts from Article 1. Section 8, the Congress shall have power to constitute tribunals this is important, inferior to the Supreme Court. Not just institute any judicial tribunal they want and make it accountable to whomever. They may only institute tribunals inferior to the Supreme Court. If an institution is performing judicial functions under our Constitution, it must be an Article III court, and it must be inferior to the Supreme Court. I think, at least I haven't been persuaded otherwise yet, that's an irresistible conclusion based on the text. It's one that probably would make a lot of independent regulatory agencies very uncomfortable. But I'm okay with that. And look, too, the necessary and proper clause. Congress also has power to make all laws shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. So Congress is given power to make laws that carry into execution the powers of the executive and the judiciary. But notice this language. Congress is not thereby given power to exercise judicial and executive powers, but merely to pass laws for carrying them into execution. That is, for facilitating the exercise of those powers by the executive and the judiciary. Plus, they're not given power to frustrate the execution of those powers, but merely to carry them into execution. I think Congress would be violating this clause, the spirit of it, if they make a law which is meant to frustrate the exercise of judicial power, which I think makes jurisdiction stripping completely outside the pale of constitutional enactments. That is, Congress's efforts to take jurisdiction vested in the courts by the Constitution and strip it from them, forbid them to hear cases which would otherwise fall within their jurisdiction. There may be some exceptions to that. I won't bore you with them, but I think there are some room for for congressional regulation, but I don't think there's much. And I think it's pretty specific. I'll mention one more thing very briefly, and then I will cut myself off. The third function meant to be served here is the framers sought to legalize conflict over the extent of federal power. I think if we look in the convention, if we look at the development, one of the problems we face under the Articles of Confederation is the fact that if the states are doing something to interfere with federal power or to frustrate the legitimate exercise of federal functions, the only remedy for that is to form an army, march down there, and take care of it by force. In other words, you only have a forcible remedy. There are two other options for this. You could institute a political remedy, some sort of political institution that would mediate these disputes, or you could institute a legal remedy, as you could fight it out in courts of law using legal principles and legal construction. I think the Constitution opts primarily for the latter. Now, the political remedy got a lot of attention in the convention. Madison initially suggested that we institute two institutions that would take care of this function. One was he would have given Congress a veto on all state laws before they take effect. Before Texas passed a law, they'd send it to Congress, and Congress would decide whether they wanted it to pass or not. The second was a council of revision, where he would have joined a number of judges with the federal executive, and they would review acts of Congress and could prohibit them or veto them before they took effect. These, Madison thought, were an adequate political remedy for disputes over the extent of federal power. Would prevent encroachment by the states on the federal government, which was the primary concern, not the other way around. But it would also prevent any encroachments by Congress on the states, he thought. We get rid of these very early in the convention. They meet with a lot of objections. And I think the primary objection is you're still very close to civil war. You're still fighting it out in a political arena, which is nasty, and it's a little bloody, metaphorically speaking. And it tends to move toward armed conflict fairly quickly. The idea was if we move it out of this, and I think by creating the supremacy clause we've already talked about, by extending federal jurisdiction to cases arising under the Constitution strips these political remedies and puts the primary remedy in the courts. That is, it provides a legal remedy. So that when we have disputes over the extent of federal power or over the powers of the states under the Constitution, we generally fight them out in court. And we fight them out using legal principles. I think if you ask any lawyer, they'd tell you disputes are a lot calmer in a courtroom than they are in a committee room, fighting out disputes before a judge with legal arguments, trained attorneys who cultivate the ability to navigate contentious disputes in a spirit of calmness and reason, is a lot further from armed conflict than fighting it out in a political committee, fighting it out in a congressional committee. And I think the concern is to remove conflict over federal power as far from armed conflict as we can get it. And the furthest you can get from armed conflict is a courtroom. And I would just read one quote, and I'll be done with this. This is Oliver Ellsworth defending the Constitution at the Connecticut ratifying convention. And he concedes that if the United States and the individual states will quarrel, if they want to fight, they may do it. No frame of government can possibly prevent it. It is sufficient for this Constitution that so far from laying them under a necessity of contending, it provides every reasonable check against it. And he says, this Constitution does not attempt to coerce sovereign bodies, states, in their political capacity. No coercion is applicable to such bodies, but that of an armed force. If we should attempt to execute the laws of the Union by sending an armed force against the delinquent state, it would involve the good and the bad, the innocent and the guilty in the same calamity. The solution for this, under the Constitution, was to provide a complete government that enforced its own laws directly on individuals. And then if a dispute arose over the application of state and federal laws on those individuals, we could fight it out in courts. Eventually that may lead to war. It did once. But hopefully it keeps us as far from civil war as can be. I appreciate your time. I won't keep you any further. I hope you have some questions, and I'll be happy to answer any of them that you do have. I was about to say, I'm not that convincing. There have to be objections, right?
I have a question in particular when you're talking about the discretion
Certainly.
the Supreme Court has over hearing its cases.
Yes.
Obviously, it is extremely valuable to them because they get to hear, like you said, 1% of what they have.
Sure.
So would you say that judicial activism is something that is inherently found in Article 3 because it seems that it essentially leads to judicial activism?
It positively encourages it. I think the last thing the framers wanted was an inactive judiciary. The one thing that is lacking terribly in the state constitutions at the time this Constitution is framed is legal principles. The rule of law had plenty of the rule of legislatures. It was arbitrary rule based on the specification of some one majority interest. What you needed was disputes mediated in courts, which would give some sort of deference not just to majority will, but to the interests and rights of the individual and minority interests over against those. And I think this does very deeply encourage it. I'd note on that point that this is the one institution in the government that has a direct contact with state institutions. The president has no supervisory power over state governors, and Congress has no supervisory power or any kind of formal contact with state legislatures. Only the Supreme Court has a direct institutional contact with state courts or with state institutions by hearing appeals from their decisions. I think that's another indication is legalization conflict. If you're going to have an institutional connection between the states and the federal government, which I think is unavoidable, there's going to be conflict, it might as well be in the courts because they're more likely to go about it in a calm and reasonable way, and one which relies not on temporary interests and temporary majorities, but on constitutional principles. Other questions? Please, berate me.
Now, when you talk about the Supreme Court, they have 9,000 cases.
Yes.
And they only get to hear like less than 1%. Now, what do you suppose would be an alternative solution to that? Like, as far as do you think they'll be able to look at all the way to death?
No. I think the solution for it is one that we've largely fashioned, and that is to increase the size of intermediate appellate courts in the system. They probably need to be larger than they are now. We have 11 circuit courts of appeals in the country, plus one court of appeals in DC, and then one more for the DC Circuit Court.